My name is Ruth Carter, and I'm a licensed attorney in Arizona, and I'm also the owner of Carter Law Firm in Phoenix. And recently, I've been getting a lot of questions about non-compete agreements. So these are contracts that your employer asks you to sign, usually on your first day of work when you're just signing paperwork left and right, and it limits your ability to work for your competition in a limited geographic area for a set amount of time if you leave your job. So the purpose of these jobs, or the purpose of these contracts, is to protect the employer, because they don't want to hire you, train you, give you all this knowledge in the industry to have you just turn around and go work for their competition. Now, these contracts are based on state law. So what is permissible under your contract is based on where you live. Some states don't allow them at all, and some of them allow contracts to say that you can't work in the industry in that area for a really long amount of time. Others are a lot shorter, like a year. So really, they don't want you working for your competition. But on the flip side, the law doesn't want you to be unable to work at all. So there has to be limitations put on it. You can still use your transferable skills. They don't want you to have a non-compete agreement that's so strict that you have to go on welfare if you leave your job. So, is your contract enforceable if you have one? Well, you got to look at your state laws. And I can tell you in Arizona, they like it. They prefer it when these contracts are very definite. And it's a really good idea to have what's called a step-down provision. So it'll say something like, oh, this contract is valid for 12 months. But if a court says that that's too long, then 9 months. If a court says that's too long, then it's only good for 6 months. Because Arizona has what they call the blue line rule, where the court can take out provisions and leave what else is left. So if your contract just says, this contract is good for 5 years, and a court says, no, that's too long, and they X that out, well, your contract basically just went away because there's no time limit put on it. So you definitely, if you are an employer who wants to have a non-compete agreement, have that conversation with a lawyer in advance to make sure that you don't write your contract so that's so broad that it won't hold up in court. On the flip side, if you are an employee, make sure you read this contract carefully before you start your job, and question whether or not it is valid. Whether you want to let your employer in on that in advance or not, that's up to you. But just know that if the contract is invalid, you may have to go to court to have it declared invalid before you can work in another job, either in the industry or in a related one. So those are the basics of non-compete agreements, and if you have any other questions, feel free to contact me. My information's below, or contact an attorney in your community. So I hope this has been helpful, and I will talk to you later. Take care.